And I am mentioning one matter for inclusion before your lordship.
My lord, I am mentioning one matter, field matter, where your lordship passed the order on 12th September. And there was a typographical mistake. I mentioned on 20th September, but the matter is not appear. The matter relates as the petitioner performing the PR of Justice. They have been ill-treated, they have been beaten.
And what is the mistake in the order?
Yes. This is the order. The first paragraph, petitioner alleging that the police authorities are taking action, are not taking action. For that reason, I came before this court. And thereafter, another is third paragraph. The last application to that, but date of the last application is also wrong.
To be mentioned. Monday.
My lord, the petitioner went to collect their flowers from their flowers garden and collect the vegetables from the vegetable field. They have been taken away and also detained in a room. This fact informed me. Some of the
No, this is a disposed of matter.
Yes, my lord.
If you want further directions, it may be a separate cause of action. For correction, we can list it.
Yes.
Then you may take
but here, what I am saying, my lord, as the appeal matter, my lord, so I am saying, considering the communication, 4th time communication was made to the SP, Purva Mirzapur, your lordship direction was to the...
Who appeared for the state in that matter?
Nil Basu and Shankar Vishwas.
Can you inform them? The matter will come up on Monday. We will do so.
Yes. Blessed the lordship.
My lord, I am troubling my lord. My recording of my name.
Matter is listed under the caption to be mentioned. In the order dated 20th September 2024, the name of the learned advocate who appeared for the appellant department has gone down wrongly, and the same is rectified, and the name of Mr. Amit Sharma, advocate, shall be shown instead of Mr. Soman Bhattacharya and Mr. Doelde. This order shall form part of the order dated 20th September 2024.
May I permit to mention a matter, Your Lordship? Your Lordship, this matter relating to the by-election of West Bengal Assembly election on 30th of November, Your Lordship. Your Lordship, this one Shongita Roy Basuya for 6 number upcoming Sitaya seat, where it is a Sidulka seat, where he filed his nomination. Fabricatingly he false information put in on her affidavit, Your Lordship, and also misleading the authority to obtaining ASC certificate, Your Lordship.
So it's a fresh matter, or
yes, fresh file, Your Lordship. The date is given here is the 14th, Your Lordship. 13th is the election, Your Lordship.
You can list it on Monday. Monday. Yes, please call. 2 matters, appellate.
Appellate side matter item number 1.
If it may please, my lord, this is my...
I beg to intervene in this matter, my lord, because, my lord, yesterday I got a judicial order, my lord, and in a roundabout manner, my lord, the petitioners are trying to stop that puja. So, Jagodhatri puja. So, kindly, I will, all the parties finish their submission. I will make my submission, my lord, but kindly let me be allowed, my lord, to make my intervene in the matter. Deeply obliged, my lords.
My lord, there's a history to this litigation. The history to this litigation is that this has been going on for years, and it's not just about one pujo. It's about pujos, it's about cricket tournaments, it's about football tournaments, it's about Christmas parties, everything being celebrated by blocking thoroughfares, which is not permissible in the eyes of law, and use of loudspeakers near a school, which is a school for the specially abled. Under the law...
last year also we have passed an order.
Yes, my lord.
116.
Yes, my lord.
What happened thereafter?
My lord, after that order, there was some peace for some time. Now, again, this year from Jagodhatri, on the pretext of Jagodhatri Puja, which is scheduled.
They are blocking the road, is it?
Yes, part encroachment has already happened, and mics are going to be installed. And the bigger fear is, if this is allowed till such time the order was in place and they've been abiding by the order. Now, once this starts, the floodgates will open, and again.
No, but they say they have obtained a judicial order.
We don't
Yesterday,
suppress the
my
order.
daughter.
Suppressing the solemn order of your honorable, of your lordships, my lord, we incorporated, we had made it
And
part
what
of
is
the
that
annexation.
judicial order?
What?
May I respectfully
lord.
hand over, my lord, the instruction?
Can I-
The
can I
order,
get a copy of it?
the copy of the order is annexed, my lord. Kindly, may I respectfully invite your lordship to the first annexure to the report, lordship. This has been passed yesterday.
The committee will ensure that
Petition.
Maybe within 90.
now the court has taken note of the fact
Yes. my
that only the pandal size will be 12 feet long, 8 feet wide.
Yes.
And the road 27 feet will be clear.
Yes.
The footpath also will be clear.
Yes.
Only thing is we can request them not to use big sound boxes.
We have already stated
May
in
I-
our averment, my lord, that pursuant to
make
your
a-
lordship's solemn order, my lord, we have already made a representation before the police authorities that will not use sound box, and we have made it a part of the averment also.
First and foremost, this.
There
We
is
will
a-
not use sound box.
There is a school for the differently abled children nearby.
My lord, may I?
You have to have some.
Yes,
concern for-
Yes.
We will not play.
Your puja committee has to have some concern for the neighborhood.
Certainly, my lord.
Particularly the disadvantaged section of the people are the children who are differently abled, and we are told that it's a residential school.
Yes.
And you
No,
create
my lord,
such
I'm-
a nuisance
My lord, it is not a residential school.
My lord.
because your committee thinks they are bigger than Ma Jagadatri.
My lord, no. I go there. I am a resident of that
So
locality.
instead of that, instead of having the idol of Ma Jagadatri, we'll have the photographs of the president, secretary, vice president of your committee.
My lord, last year also I had gone there.
You-
I tell your lordship, an officer of the court, I tell your lordship, the Ma
All right,
Jagathatri,
we'll appoint you
observe-
as a special officer.
Ma,
You go and stay in that place for the entire puja period, and you ensure peace in the locality.
my lord, may I, my lord?
Yes.
My lord, may
Yes.
I? My lord,
We'll do
Jagathatri,
that here.
my
We'll do
My
that
lord,
here
there
and
is
now.
one small suggestion.
Jagathatri Puja over there is observed with all rituals. There is no photograph of any
Let there
president,
be
any
the, let there be
No,
the
no,
rituals.
I am suggesting to you, instead of Ma Jagadatri statue or Dala, you please keep the president's photograph, because president thinks he is above the deity.
My
This
lord,
is all sheer ego, man. This is all sheer ego.
my lord,
Strength, show of strength. I am bigger than everybody.
No, my lord. I place, may I place
No,
before your lordship?
Can you deny the fact
Yes.
that there is a residential school for the differently
Yes,
able?
that is not a
No,
residential.
that is not a
school.
residential school,
is
my
not-
lord. It's not. But it is a school for specially able.
They
But
are
it is a
petitions-
school for specially
they are
able.
petitions
school
also,
and-
my lord. It's a day school.
It is a
11
school for
to 3.
specially able, yes.
11 to 3. Those schools are all along
We
this.
can do one thing, we can so moto entertain an appeal against this order and grant stay of this order.
My lord,
Next year, we will hear both of you, all of you file affidavits, and then we will.
already
May I-
the puja has started. My lord, I leave it to your lordship.
No,
May I make a,
Puja has started.
you should have some regard to the people of the locality. Do you mean to say the police can enforce saying that you have, your puja pandal should be 12 feet? Suddenly you make it 16 feet? And what will the OC do? You will honor him, you will bring him there, put him shawl, etc., give him a big gift, take photographs with him. Matter is
My
over.
lord, already we stated in our
More than 3 years I am here, madam.
my lord, already in the
And
petition.
I have visited Chandranagar last year for Jagadadir Puja. This year, I don't propose to go.
Maybe that is
Lordship
Chandranagar, my
might
lord.
have
My-
seen
I am-
all the
I am
other
an officer
duplicate
of the court,
pujas.
my lord. Kindly, yes, last year also I had gone there. We have halved it, my lord.
my
The
lord, there
pandal.
is a park.
After your
There is
lordship's
a
order,
park
my
where
lord.
we had only suggested that you hold it in the park,
We
which is
can't
within
do
a-
anything because if you are aggrieved, you have to challenge this order.
Yeah, my lord, this order was actually, I don't know, it
But
was
one
not
thing-
served on
We
us.
also don't know. Just now,
This
the
was not
government
even
has-
served on us, this writ petition. This order was just.
May I
public interest
This is the
specifically point
problem.
out one paragraph, my lord? Yes, stand taken is very contradictory by my learned friend appearing for the petitioner.
How?
In para 4, he says, except in Durga Puja, we are not going to allow any other puja. So you can hold Durga Puja with fanfare in that area for you because you are there.
No,
Oh, he's a
Para
challenge-
4, kindly cease para 4.
no, no,
My lord.
Kindly cease para 4.
no,
Lordship.
not that.
No,
Uh,
I am going by the averment.
Yes, yes.
This is a writ petition filed as a public interest litigation, praying for various reliefs, and in particular to restrain the respondents from conducting a puja in the place which has already been earmarked for which the police have granted permission. As rightly pointed out by the learned government counsel, the petitioners do not object for conducting of Durga Puja in the very same location, but are objecting
it's
to
not in the same
conduct
location,
of
my
other events.
It's not in the same location. There is no Durga Puja in the same location.
The learned advocate for the petitioner would submit that the location where the Durga Puja is conducted is a different location. Be that as it may, the Puja committee, namely Jodhpur Park Ananda Sangha, had filed a writ petition before this court in WPA 26577 of 2024, and the same has been disposed of, taking note of the stand taken by the Puja committee as well as the stand taken by the state, and that specific restriction has been made with regard to the pandal size and to ensure that 27 feet of the road is absolutely kept clear, and both the side footpaths will also be clear. The petitioner would point out that there is a school for the disabled children in the locality, and if loudspeakers and sound boxes are used, the children will be put to prejudice. The learned advocate appearing for the intervener, who appeared for the petitioner in WPA 26577 of 2024, submitted that the Puja committee has given a written undertaking to the police that they will not use sound box. In the light of the orders passed in the said writ petition dated 7/11/2024, no contrary order can be passed in this public interest litigation. However, we would observe that the Jodhpur Park Ananda Sangh, namely the Puja committee, shall have due regard to the people of the locality and ensure that none is put to inconvenience on account of conduct of the puja. The order and direction issued in the writ petition dated order dated 7/11/2024 shall be strictly complied with, and any other direction that may be issued by the state administration shall also be complied with by the puja committee without default. Disposed of. Next.
My lord, the
Very,
report,
very
the
grateful,
report
my
may be
lord.
retained with the record.
Yes.
Extremely
The
grateful, my
report
lord.
submitted by so and so retained on that. You just say for interview. Yes. Next,
Lordship disposed of, Lordship.
Very, very grateful, my lords.
yes, what happened?
Out of 8 writ petitioners, only one person's certificate is lying with me.
Hmm.
Others are not.
You have handed over.
My lord, we haven't received it yet because the particular person whose certificate he was here was on his way. He couldn't able to make it. And my lord, so far as the others were concerned, the 7 candidates who were there yesterday, they were compelled to leave because they are coming all the way from Bakur and other places. They have to leave. Their certificates were not here. We are not being given anything.
What are the names of those 9 candidates?
My lord, it is in the writ petition, my lord.
So where are those certificates? Can you get those?
Blood. My junior called him. He told me that these certificates are lying to some other colleges. Blood, kindly let them personally present before your lordship.
My lord, these things have been going on for an indefinite period of time.
Despite directions.
My lord,
issued
state
from
was
time.
directed to file a report.
Warrant of arrest was
Regard
issued
to
on 2 occasions.
function.
Yes, 2 of
My lord,
the warrant of arrest.
instead of my lord injunction order, they are continuously violating the injunction order, my lord. I have handed over some
No,
photographs and
let
some
the
related documents. my lord.
Ziaul Haq and Saeed Ali Chowdhury appear.
Absolutely.
Um,
We are in possession of the sale
in
deed.
spite of repeated directions, the 2 persons, namely Ziaul Haq and Shahid Ali Chowdhury, have not handed over the original certificates and credentials to the 9 candidates who were present before this court. The certificate of only one candidate is in the custody of the learned advocate who is appearing for those 2 persons. It is submitted by the learned advocate that his junior colleague had contacted the 2 persons over phone, and they were informed, and he was informed that the certificates are lying in different colleges. Therefore, we deem it appropriate to direct the personal appearance of Zia Ibrahim alias Ziaul Haq and Shahid Ali Chowdhury before this court on the next hearing date, and on that date, the said 2 persons shall bring all the 9 certificates of those candidates and place it before this court.
My lord, pursuant to the earlier order, I am filing the report with regard to the status as to whether the colleges are functioning or it's not functioning.
It's not. In terms of the directions issued earlier, the
29th of
inspector in charge of Bankura police station has filed a report dated 30/9/2024 stating that the team of Directorate of Health Services West Bengal visited the campus of CAMPS College or Saubhagya Nursing, Bankura, both headed by Mitra Pada Ganguly on the same day, and found few flags are displayed as Bankura Institute of Medical Sciences.
My lord, may I interrupt one thing?
The authorities, namely the authorities of the Directorate of Health Services West Bengal, as well as the inspector in charge Bankura police station, is directed to forthwith remove all the flex banners which have been displayed in the said premises, styled as Bankura Institute of Medical Sciences, and take photographs and produce it before this
My
court
lord,
on the next hearing.
may a copy of the report be provided to us? Since we are in possession of the sale deed, the particular institution is already been disposed of during the
Yes, my lord.
order of the injunction. My lord, this is the sale deed, my lord.
They will remove the banner, don't worry.
My lord, already photographs have been annexed to this
We
report.
saw that. Those banners you please remove.
My lord, may a copy of the order?
Flex banners have to be removed. Direction issued.
My lord, may a order be report be given to us, my lord? Copy of the report.
Yes. If you want, we'll give, you take photocopy and give.
My lord, may.
When do you want to list?
আমার থেকে একটা copy কি তোরা জেরক্স করে নিবি?
ছবি তুলে নিচ্ছি ভাই।
No, 21st. 21st November.
21 নভেম্বর।
21st.
Grateful, dear দর্শক।
How to communicate? Earlier, The registry is directed to communicate the order to the said two persons as was done earlier. That's all. Now, original side. Item 1, 2, and 3 are all below tax. Sir, you take down common order. This appeal has been filed by the revenue, challenging the order passed by the income tax appellate tribunal. It is not in dispute that the tax effect involved in this appeal is much lesser than the threshold limit fixed by the CBDT. Hence, the revenue cannot prosecute this appeal any further. Accordingly, the appeal stands disposed of on the ground of low tax effect, and the substantial questions of law are left open. This will be same order for 1, 2, and 3. Then you can call item 4.
Item number 4.
What is the contempt?
I am for the petitioner. The petitioner who had filed a PIL before my lord, and my lord was pleased to pass an order, and the PIL was in respect of 10 properties situated in the.
But it has to come before the other division.
No, my lord, that is an error on in the cost title, the printing. The order is of 23rd February, and my lord, the order is at page 92. My lord, the order was passed by this honorable division bench, my lord. My lord, will kindly come to annexure C2, which is at page 92. My lord will see that the division bench is correct.
What is the contempt?
My lord, the contempt, my lord, in respect of there was 10 properties. My lord had passed an order directing that the properties be sealed.
No,
If
see,
my lord kindly
wait,
come.
wait.
Yes, my lord.
After that, the matter went to
Supreme Court.
Supreme Court. Some orders were passed. There are several CAN applications which
My
have
lord.
been filed. On what date the other matter is coming up?
My lord, that matter is, my lord, I'll have to take instruction. That matter will be coming up later on. But my lord, the issue is in respect of.
No. We will list this contempt petition on the same day along with the writ petition.
My lord, I was only seeking for notice in any event.
No,
But
no,
my lord, one
We
thing I
will
want to
consider.
highlight, my lord,
No.
there has been construction in the premises,
No,
third
it's not as
premises.
simple as you projected at the first instance. There is something more to be said on that. That WPOP 1 of 2024.
1 of 2020.
All right. List this contempt application along with WPOP 1 of 2024.
In the meantime, my lord, may I serve notice?
No. Unless we permit, you can't serve. Next.
Because my lord, construction, 4th floor has been constructed in a property which has been sealed by the.
We can demolish, sir. We can
My lord.
always demolish.
My lord.
Next.
Item number 5.
How many days?
Has to go, my lord.
1864.
263.
1864, my lord, it has to go. Delay is, my lord, substantial.
See the name of the assessee.
Yes, my lord.
Very powerful people, sir. Your clients. We have heard so and so. There is a delay of 1,864 days in filing the appeal. The order was passed by the learned tribunal on 28/9/2018, and the copy was received by the department on 9/11/2018. However, the appeal has been filed on 15/4/2024. The 24 with a delay of 1,864 days. The delay is inordinate and not explained. The affidavit filed in support of the condone delay application does not set out any acceptable reasons for exercising any discretion in favor of the appellant department. Therefore, the application is dismissed. Consequently, the appeal stands rejected.
I'm grateful.
6, my lord, similar situation, 1449 days delay. But in that matter, my lord, there was a direction to file affidavit. All things have been done. But there's a similar matter, my lord. The issues are similar in both these appeals.
That is serial number 6.
6, my lord.
Same order.
Item number 7.
Only my lord, number of days will change.
Number of days is 1449.
You know, but since my lord said, please to mention the dates also, the date of the order.
Oh, date of the order also will change.
But the date of the order is not 19th June.
No, that we'll incorporate. 19/6 are the 3 dates. 19/6/2019, 26/8/2019, 12/12/2023.
I'm grateful.
Item number 7.
Here the delay is 67 days.
We're not going to, opposing delay might, if it may be taken up another date.
Oh, we have heard of Riyak Dutt, etc., Soman Bhattacharya, Prithvish Junjunwala. There is a delay of so and so days in filing the appeal. As the explanation offered is acceptable, the delay is condoned. Application allowed. Next.
Grateful, madam.
Item number 8.
Alan.
This appeal has been filed by the department, Income Tax Department, challenging the order passed by the Income Tax Appellate Tribunal, C Bench, Kolkata, and ITA number 483/KOLs/2017 for the assessment year 2012-13. The appeal is time barred and it has been filed with a delay of 2040 days. The order, the learned tribunal passed the impugned order on 12/9/2018, the certified copy of which was received by the department on 4/11/2018. However, the appeal was presented before this court on 3/10/2024 with a delay of 2040 days. We have perused the affidavit filed in support of the condone delay application and we find no acceptable explanation for the inordinate delay. Therefore, we are not persuaded to exercise any discretion in favor of the appellant department. Consequently, the application is dismissed and the appeal stands rejected.
I'm ready.
Restoration application, item number 9.
This is my application for restoration. Lord. The appeal was dismissed on 3rd of May 2024. Lord, at paragraph 3 and 4, we have explained the delay in filing this application. Lord, there's a 130-day delay in filing this restoration application. It was item 408 in the lordship's list on the day.
So the appeal was admitted, is it?
Yes. Yes. Appeal was admitted.
The appeal was admitted. Lord. The appeal was admitted on 13th of February 2020.
So the department will allow this. We have heard the learned advocates for the parties. An application has been filed to restore the appeal, which was dismissed for non-default. We find that the appeal was admitted on 13th February 2020 and paper books have also been filed. However, on the day when the matter was called, it appears that the learned advocate could not be present and therefore the appeal was dismissed. Considering the fact that the appeal was already admitted and it has to be seen as to whether there is any substantial question of law arises for consideration, we exercise discretion and allow the application and restore the appeal to the file of this court to be heard and disposed of on merits. Yes.
Deeply obliged.
Item number 10.
I appeal for the respondent writ petition, my lord.
My lord, by the impugned order,
Yes.
my lord, on the first day, without my lord calling for affidavits, the writ petition has been entertained and finally virtually disposed of. But at the same time, my lord, directions have been given for exchange of affidavits. My lord, before I invite your lordship's attention to the order, kindly indulge me a moment for my lord giving your lordship the background. My lord, the appellant before your lordship is the Food Corporation of India. Now, my lord, we have, my lord, a scheme for all our, my lord,
Employees.
workers, my lord, employees, of course, workers also, whereby, my lord, we have identified certain hospitals. And anybody who, any of our workers, including their family members, if they have a problem, they can go, they can avail of the medical treatment, and the hospital raises a bill on me. My lord, the respondent number 1 is one such hospital, my lord, who is, my lord, registered with us. My lord, this has been going on with various hospitals. Now, with regard to this hospital, my lord, we ultimately discover a scam, whereby, my lord, it's being shown, my lord, that various people are availing treatments, bills are being raised. Food Corporation of India, my lord, is a large entity, and, my lord, bills are being paid freely. So, my lord, ultimately, my lord, when this was discovered, now, my lord, the contract between the parties contains a clause that, my lord, the bills will have to be paid within certain given time limits. So we've been paying, my lord, because bills have been raised, we have been paying, because otherwise, my lord, that clause comes into effect. Ultimately, my lord, when we find out, my lord, that there is a large scale, my lord, what we, my lord, perceive to be fraud or irregularity, my lord, we, my lord, issue a show cause notice, my lord, to the nursing home for a period covering 2017-18. Now, my lord, this writ petition, my lord, is directed, my lord, at, my lord, non-payment. In other words, my lord, it's a writ petition for recovery of money. That these bills of ours have been raised, they have not been paid direct. And, my lord, on the first day, my lord, the learned single judge appears to hold that your show cause notice is only for this 1 year period. So, leaving that apart, everything else you pay. And further bills can also be raised, which will also have to be paid. Now, my lord, we had, my lord, certain reservations about the maintainability of the writ petition, of course, my lord. Contractual matter, fraud. As a matter of fact, my lord, when we discovered this, not only did we stop their bills, we, my lord, made a complaint to the CBI. These are, my lord, things, my lord, which have to be brought on record, for which I have to file an affidavit. My lord, today my problem is that, my lord, they filed, my lord, a petition, my lord, for contempt, which was appearing before the learned single judge today. Of course, he was gracious enough, my lord, when I pointed out that the appeal was pending, my lord, to, my lord, defer it for a period of 2 weeks. So, my lord, I can address your lordship on the appeal today itself. But, my lord, at least today, my lord, I need an order of protection, my lord, that the contempt should not be proceeded with. But, my lord, I'll just indicate, my lord, now, my lord, if your lordship can...
Now, the show cause notice is for 17-18.
Yes.
Now you are also probing into the other bills for 18, 19, 20.
Yes, my lord, they have, my lord, after the passing of the order, submitted a further bill upon me for about not much, my lord, 15, 18 lakhs. Now, my lord, my difficulty is, my lord, that those bills for 17, 18, I've already paid. So, my lord, what we were...
No, the direction is to pay for the remaining period, is it?
Remaining period. Now, my lord, whatever I've already paid with regard to the disputed bills, because, my lord, I tell your lordship, my lord, like I told your lordship, my lord, I am duty bound to pay the bills within a given time. But, my lord, if I find that you've taken, my lord, money against bills which were not payable, and, my lord, there is a particular clause to which I'll invite your lordship's kind attention, which says...
You can recover, I mean, adjust.
Yes, not adjust, my lord, these say that entirely at my discretion, whether it's payable or not.
No, 17, 18, if according to you, monies were not payable.
18, 19, I'm sorry, my lord, 17, 18 is not, 18, 19.
All right, 18, 19, according to you, the false bills were raised and you have paid. And ultimately it is found that there is a mistake in payment. That amount can be recovered from him or adjusted against other genuine bills.
Correct.
Which may arise in future.
Lordship.
Now, have you blacklisted them?
Now, my lord, we have not yet blacklisted them because, my lord, they are still under the show cause period. And maybe, my lord, I will accept their show cause, I don't know. Not only that, my lord, I have taken, my lord, steps against my own officers because, my lord, this is obviously can't be done, my lord.
Exactly.
My lord, two hands required to...
You.
Those are things which I'll bring on record. Kindly have the...
What is the direction issue?
My lord, kindly have this direction. My lord, kindly first take... my lord, may I first take your lordship to the direction and then, my lord, kindly take the second last paragraph onwards. That apart, it is arguable as to whether the FCI has to establish losses suffered by it for the action of the petitioner prior to forfeiting the dues, even for the period 2018-2019, as to whether sufficient cause was made out by the petitioner in the reply to the show cause notice. Accordingly, the writ petition shall be heard on the above issues, shall be listed for hearing on so and so. Respondents shall file their affidavits, if any, shall be filed by so and so. The respondent FCI shall disburse all the dues of the petitioner in terms of the bills for the periods other than those pertaining for the financial year 2018-2019 as expeditiously as possible, but positively by such and such date. Respondent FCI shall remain restrained till disposal of the writ petition from refusing to accept bills tendered by the petitioners for subsequent periods, including their current dues. So, my lord, nothing remains of the writ petition. My lord, even upon the disposal of the writ petition, I don't know, my lord, what further relief my learned friends will ask for, except, my lord, for the disputed period. Now, my lord, if your lordship will kindly, my lord, see, my lord, the question of maintainability of the writ petition, my lord, has not been, my lord, at all, my lord, addressed, my lord, in this order, my lord, which I seek to assail before your lordships. The question of the maintainability of the writ petition, my lord, when there's a question of fraud involved, my lord, I don't know. And my lord, this is for recovery of money. My lord, I am not for a moment, my lord, arguing the proposition before your lordship that, my lord, contractual matter and money matters can't be, my lord. But, my lord, there must be an element of public good attached. It must have an element of public character. Only then, my lord, these are entertained.
In fact, we had an occasion to decide one matter that are also related to money claim. You had appeared for the writ petitioner in that? No. Where we had dealt with all the, in fact, the learned single bench referred to a couple of decisions of the Supreme Court. I don't know whether it is Coal India. Yes. It's an educational institution under the control of the government in respect of some civil construction which was done.
We shall pull it out, my lord.
And we allowed the appeal, set aside the direction for payment of money.
My lord, we shall pull it, my lord. I shall pull it out, my lord.
In that matter, we have referred to these decisions also.
Lordship.
And pointed out the exceptions which were carved out by the Honorable Supreme Court. Of course, the decision of the Supreme Court says with the disclaimer saying it is not an absolute bar. A writ petition is maintainable for a money claim. Nonetheless, they have laid down what are. One thing is there should be a public element involved, this, that, etc. But then what remains in the writ petition?
Lord, I'll indicate what remains after this order. Lord, firstly, let's be fair to a learned single judge. This two issues had arisen.
But that can always be done in
later on. Now, two issues. Now, a submission is being that I want to file an affidavit. This direction your lordship would have seen was passed by an order of 14 December 2023. No affidavit has come to be filed. There's nothing is on record today. No affidavit has been filed. After I file the contempt, they prefer the appeal. They don't do anything with regard to it. Now, what is the status of this matter? Why this order was passed? FCI is entitled to withhold bills. The clause, if your lordship looks at page 24 once, and this is the clause that a single judge has also interpreted. Kindly have a look at page 24. Last clause, I'm just hoping your lordship's page is slightly more legible than mine. FCI shall not be liable to make any payment on account of claims which are in the opinion of FCI fraudulent or as a result of fabricated claims. Corporation would have the right to blacklist the hospital if the hospital is found to have the lodging of false claims without prejudice to any other rights that the corporation may have under the law. So liability is otherwise absolute. They can withhold when my claims are fabricated. They can issue a show cause. This period is from 2016 to about 2020. The show cause notice admittedly pertains only to 18-19, and they withhold bills which were before and after. So there is no question of there being any fabricate. There is no other show cause. There is no prevention on FCI to issue any other show cause.
It is basically a civil claim, sir. As per the terms and conditions of the contract, you have to approach the civil court. Let's see clause number 2 at page 28, clause 1.10. And in fact, Mr. Banerjee, we had considered this issue also in another appeal where Coal India was, they also said the same. Who argued?
Look, claim of for the year 2016, can you recover?
Well, that was
by filing a writ
the
petition
limitation was something
in
that
the year
I had to
2023.
Look,
this claim, what actually became ripe after the contract after contract was over. I have to give them the bills and then they release the claims. So this was ripe sometime around
The point of
2021.
limitation has to be decided whether it was at all recoverable at the point of time when the writ petition was filed.
This point of limitation would have to be taken by them.
What we get,
In an affidavit,
we will put this order on hold for a period of 2 weeks. He will complete his pleading by next week. We will request the learned single bench to take up the matter, probably within 3 days or 1 week. You file your reply. We will fix the matter.
Only with regard to the aspect of stay. Could I just address your lordship on two issues? May I
But
just
then
place?
It is virtually allowing the writ petition.
Lord, today, kindly have a look at my prayers in the writ. There are
Because
two
we have
other
been
aspects.
party to not one but two decisions. And Anjan, who appeared in that? Jishnu Chaudhary and Sabhabatra. What is his name? Datta.
Rajashri Datta.
Subhabhadra Datta. That was also a case where there was a condition that Coal India can withhold payment in respect of the subject contract or any other contract. So the learned single bench, the very same learned single bench, interpreted the terms and conditions and said that within 90 days, it could be exercised. The very same writ petitioner was a JV partner in another contract. There was a fraud committed, CBI, etc., arrest, etc. Matter is now pending before arbitration. In another contract, they wanted this money claim, and this was. We have extensively considered that matter.
If that is the view
of interpretation of the terms and conditions of contract, whether the court will be justified in interpolating or interpreting the clause, and we allowed Coal India's appeal. If you ask Jishnu, he will be able to give that.
I should do that.
Kindly keep it on Monday and hunt this out. Kindly do not pass any order today. If this is the view of the
Best
bench.
thing, sir, because money claim, of course, then we will have to shut down the civil courts. No court fee, standard court fee, you remit.
No lordships have
no,
held that in respect of money claims.
In one of the matters, we have decided that whether a time-barred claim in an indirect manner by under Article 226, it can be recovered.
The law is also clear on this, that where the authorities have replied on merits.
No, you take an order on merits. You take an order on merits.
This is on merits, I'll tell you.
This is at the first instance. Suppose on the day when the appeal comes up, we issue a positive direction that clear up all the dues. They are not going to run away. It's a public sector. And you are an established medical center. And who did it, we don't know. 100% it is the officers or employees of FCI.
No, that is
who are party to the scam. If at all,
May I just indicate one thing? Well, there is an agreement which entitles FCI to withhold payments. So the liability is made subject to a show cause. Remaining period, well, however it is be canvassed, remaining periods, there is no dispute. There is nothing on record to show that there is a dispute with regard to the remaining period.
No, it is too early. It is too early.
Even here, they've not been able to come up with that. They have come up with one document. Well, your lordship is interfering with the order passed by learned single judge. I'll just take one more minute.
No, please. We are not restricting.
Nothing is on record. Firstly, nothing prevented this appellant from filing an affidavit in opposition in all these months, from December to October, November. 1 year they've not filed an affidavit. Now to say I want to file an affidavit.
You have not been a standing counsel for any of the state undertakings.
I'm sorry, Mullah.
You have not been a standing counsel for any state undertaking. You need to have a stint, at least for 1 year. 11 and a half years I have been there. There are so many issues. Today we have dismissed 3 appeals. Senior was appearing. Very powerful SSC in the state of West Bengal. Every appeal is delayed by more than 1,500 days. Individual SSC, poor fellow doing some small business, salaried employee, selling one flat, buying one flat for daughter, notice issued. He succeeds in the tribunal. The appeal is filed in time. There are so many issues, sir. So many.
Here
issues.
also the appeal filed in time.
You prepare a
January.
draft affidavit in opposition. As many as 7 officers will have to vet it. See, sir, you, depending upon whom you have implemented as the first respondent.
And then
You say principal secretary, done.
Well, in fact, now, even if I'm not an empanel lawyer with anybody, in some matters, people have approached me, where when authorities have come and I am vetting
And the best part is trying to get your bills, trying to get your fee bills settled. You see, ask any of them. We have been monitoring that. And thankfully for the intervention of the learned additional solicitor general, some payments have trickled. Very difficult. They want them to even pay the court fee, out-of-pocket expenses, photocopying expenses, clerkage. Advocates are not required to
This
do
is
that.
primarily why I am not on any of these panels.
You need to be, sir.
This is why I'm not.
You need to
But
be.
could I just indicate this? Well, in this application also, so today, whatever time it may take, FCI does not have its version on record. They have a stay application. In the stay application, they have some new additional documents. I'm taking them to be, that they can file it here. That also pertains to 1819. Well, there is nothing on record even before this court that allows them to withhold payments because why was the direction passed? Because this direction was passed because this is a part of the order in the notice to show cause itself.
Did your client make an internal audit on this?
Yes, yes. I'll tell you, Lordship, what has happened. From 16 to 20, what is the arrangement? They send me patients. I look at these patients. These patients are treated. Then these patients are allowed to go. I raise bills. They are supposed to issue a particular document. I take that document and go ahead and raise the bill. Those bills get cleared. Now, these patients have all been treated. When I raise my final bill, they say that 1819, there is a fraud with regard to, there's a fabrication of claims and it's restricted to 1819. Knowing Mr. Shah is also very fair, he says it's 1819. In the order pertaining to this show cause, why has this learner single judge passed this order? Is because in the order pertaining to this show cause, there's a direction that my payments are going to be withheld, which are outside the period of 1819. So it's a question of jurisdiction. But I have not come, I'll show that paragraph. And that is why
probably further probe may lead into something else.
What they will do in future, I don't know. But 1819 till 24, nothing has happened.
This virtually tantamounts to allowing the writ petition.
No, writ petition, I'll tell you, Lordship, why. Just have a look at one document. Just one reason why it is being canvassed that I have filed a writ for payment of money. But it's the other way around. It's a question of jurisdiction because a show cause pertains to a certain period. Benefits have been withheld for a period beyond the period of show cause.
No, you have challenged the show cause.
I challenged the final order. That's what I wanted to show.
Yes.
Page 119, if your Lordship see.
Page 82 is the prayer to quash the communication dated January 13, 2020, show cause dated July 26, 2021, yes. And the order of respondent number 3 dated November 18, 2020.
That's right. So
2021.
That's the final order. So what remains in the writ is I succeed in the writ, then the entire payment gets made. Kindly have a look at page 119 once.
And when did you file this writ petition? 2023?
In 23.
And the order was passed in 2021. Show cause notice was issued in the year.
Order was passed on 18th of November or 2nd of December 2021.
No.
Look, just one paragraph. Kindly have a look at it. Kindly comes to 119 once. Well, this is not a case for implementation of a money claim.
Therefore, when the writ petitioner took his own sweet time of 3 years to challenge the order, you can wait till the affidavit in opposition.
But I have challenged the order on the ground that you can't issue directions which are beyond the scope of the
when the writ petitioner blames the appellant for not having preferred the appeal immediately after 14th December, the same test has to be applied to the
I'm not blaming that. Well, the argument was advanced that I want to file an affidavit. Nothing, irrespective of the hierarchy, nothing prevented
it. We have heard you, sir.
Just one more minute, just 1 moment. Kindly comes to 119. Well, I'll be fair to the learner single judge and then your Lordship will just decide that issue. 119 is the order which is assailed by the FCI. Kindly turns over to 120. Look, second paragraph. Just give me 1 minute.
All the contentions in the reply were deliberated upon, and the same were found to be unconvincing, unacceptable, untenable.
This is something that we have shown to a learned single judge. Kindly have a look at it. Second paragraph, kindly have a look at. So in my defense, when I showed 1819 bills were not fabricated, I showed a letter which was dated May 2019. November 2019. Please give me that repetition copy so I can read it out. That was disallowed because I had relied on documents which were outside the period of show cause. On that ground, my case was disallowed. And then the final order is 120 bottom. May I just place that?
Or we can do one thing. We'll get the list of the employees who were 135 surgical cases. We'll send them to SSKM and find out whether surgery at all was performed.
I'm sorry, Miller.
We will get the list of 135 surgical cases which you have dealt with, and send those employees, workers to SSKM to find out whether at all any surgery was performed on the worker or the family member.
This is
no
not just-
surgery performed. We'll close down your hospital.
Let us only 1 minute. Let us just take it that the show cause is correct. Just if I may just kindly come back to 121 paragraph, your lordship will allow me to place.
And it's not a small sum, sir. It runs to almost 2 crores.
Which is why 2 crores, kindly will look at this one paragraph, second paragraph. All the contentions as contained the reply were deliberated upon and the same were found unconvincing, unacceptable, untenable. The contention of the hospital that the bills were thoroughly examined before passing at the end of the corporation does not absolve it from any discrepancy or malpractice found subsequently. As per the hospital's contention with regard to difference or variation in discharge summary from FAR is concerned, the procedural parts, including the variation between the discharge summary and FAR, remain same throughout all the previous years, and as such, the same cannot justify higher expenditure in a particular year, which is instant cases 2018-19. So all the other years were correct. Now kindly have a look at the next sentence. Further, the contention of the hospital regarding unilateral decision on the part of the FCI to include specialist consultant visiting fee up to 2 visits with room rent was not agreed to by the hospital. Referred to above has no legs to stand as the matter pertains to year 2018-19, whereas the letter is dated 26 November 2019 beyond the relevant period. So when I say, look, I had been authorized by FCI itself, and on that basis, I've gone ahead and done everything. There's a 2-pronged check that the agreement contemplates. And I've done that. And there's a letter of 26 November 2019. The order is that this pertains to a period outside the show cause. Therefore, it can't be countenanced in law. Then a direction is passed. This weighed on the learned single judge to hold that if you have found what is done prior is correct, and that can't lead to a 15% hike, and you've not allowed them to rely on documents which is outside of 1819, then you can't withhold.
So therefore,
It's
prayer F and G in page 84 has been allowed.
Just give me 1 minute.
Page 84, prayer F for a mandamus to command the authorities to forthwith disburse 188,46,307. And the second one is to permit them to submit bills. This has been allowed. Your main relief has been allowed at the interlocutory stage without an appeal. Please come, sir.
F and G.
This intra-court appeal has been filed by the respondent in WPO 1664 of 2023, challenging an interim order dated 14th of December 2023. By the said interim order, a positive direction has been issued to the appellant to disburse the dues to the writ petitioner in terms of the bills for the period other than pertaining to the financial year 2018-19, and also the appellant has been restrained till the disposal of the writ petition from refusing to accept the bills tendered by the writ petitioner for the subsequent periods, including current dues.
This bit, your lordship, will allow me to at least submit the bills. Post 2018-19, there is no dispute. There is no show cause.
We find that the relief granted by to the writ petitioner is in fact the reliefs which have been prayed for by the writ petitioner in prayer F and G in the writ petition. The learned single bench was also conscious of the fact that to decide the matter finally, affidavits have to be called for and accordingly issued appropriate direction. The issue which is raised before us, which is in the nature of a preliminary objection, is regard to the maintainability of the writ petition, which admittedly is a money claim. We find that a show cause notice was issued to the writ petitioner sometime in 2021, alleging that fraud has been committed with regard to certain claims, certain bills submitted by the writ petitioner for the treatment said to have been given to the workers of the appellant organization or their family members. The writ petitioner submitted reply to the show cause notice, and ultimately an order has been passed on November 18, 2021, by which it has been held, by which the appellant withheld the amount of rupees 1,79,67,988 payable to the writ petitioner as full and final amount pending outstanding against the appellant corporation, incorporating bills already submitted and outstanding bills for the expenditure incurred in the relevant year and for which bills yet to be submitted by the hospital, is forfeited in full without prejudice to any other rights and remedy the corporation may have under the agreement and law, and further reserving its rights to recover pecuniary loss in accordance therewith. We find that the matter requires examination on various aspects, including whether a writ petition with a prayer as sought for was maintainable with regard to money claim. Secondly, even assuming such a writ petition was maintainable, whether such a money claim was barred by limitation or not, if the writ petitioner had chosen a common law remedy, could be made in a writ petition filed under Article 226 of the Constitution. Thus, we find that the relief granted at the interlocutory stage is virtually allowing the main writ petition so far as prayers F and G in the writ petition, which in our opinion could have been done after affidavits were exchanged and the matter was heard finally. Therefore, we are inclined to interfere with the impugned order. Accordingly, the appeal is allowed and the impugned order is set aside, and there will be a direction to the appellant, who is the respondent in the writ petition, to file their affidavit in opposition not later than 14th November 2024, reply if any before 22nd November 2024, and the writ petition shall be listed before the appropriate learned single bench in the week commencing 25th November 2024. Liberty is granted to the learned advocates on either side to mention before the appropriate learned single bench about this order and requesting the matter for an early hearing.
Kindly make this timeline preemptive. This timeline to file the affidavit preemptive. My 2 crores is also pending. They've wasted 10 months.
If the appellant does not file the affidavit in opposition within the time fixed, the same and any extension is sought for, the same will be subject to the condition that the appellant pays a sum of rupees 10 lakhs to the writ petition. What about yourself?
But in that case,
everything.
but I'm deeply obliged. In that case, may I ask for some more breathing space? Kindly increase it by 4 more days.
Then you do one thing. Instead of 14th, you say 19th now. And reply, if any, by 22nd now. Because senior advocate is appearing, so 10 lakhs.
Now, while physically.
I'm so grateful to your lordships. I'm so grateful.
Next.
Grateful.
Item number 11. My lord, I'm appearing for the appellant bank, my lord.
My lord, OTS proposal the borrower has sent us and we are considering that. So my lord, at least fortnight time is required in case we
We'll
arrive.
just adjourn. We will not record anything.
Then in next week, if the matter appears.
No, we'll adjourn it by 2 weeks.
2 weeks. Grateful,
We
Your
will
Lordship.
not record anything.
Grateful, Your Lordship.
At the request, the respondent has been served.
Yes, my lord, I have served by hand.
There is a delay.
There is a delay of 60 days because it pertains to Agra branch. So
Okay.
to give
Now,
us.
where is your affidavit of service?
Yes, my lord. I have served by hand because the advocate and records address was written in the previous writ. Accordingly, I have served by hand. This is the copy.
In the Alkayal. All right. There is a delay of 60 days in filing the appeal. The respondent has been served and proof of service has been filed. Since the delay is not inordinate and has also been explained, the delay in filing the appeal is condoned, application allowed. List the appeal in the week commencing 25th November.
Grateful, Your Lordship.
For admission tax, item number 12.
Your Lordship, before the start, can I say something? Your Lordship, this is a matter where I have suggested the client to go to VSVS.
Yes.
Because Your Lordship, I'll give you Lordship two things which they have restricted in the VSVS again, which they have done in 21 VSVS. They have done it here again. They have put the cutoff date, as Your Lordship can see in eligible cases, 22/7/24 in paragraph 2, comments portion. First page, Your Lordship. Para 2.
Yes, 22/7/24.
22/7/24. In this, my case, Your Lordship, the tribunal order was passed on 11/1/2024. Lordship, then the last date of filing the appeal was 6/7/24. Lordship, they have filed the appeal after 55 days, which you have condoned. Your Lordship, now in a similar type of case, in the last VSVS, Your Lordship was kind enough to pass an order, and I am giving that order, Your Lordship, where the VSVS was direction was given because after a lot of fight, the SSC could get the VSVS. When I want to get an exit, when everybody is getting, why a cutoff date of such date where they have filed a delay of appeal? So Your Lordship may kindly come to page 5 of your order, Lordship. Your Lordship, here in the page 5, the second issue would be whether revenue can now contend the circular dated covers cases where the appeals are filed with an application for condonation or delay. Same on important issues. So Your Lordship, after dealing with this issue, one important issue which the revenue has lost sight is the appeal which is filed before the court on 8 January was time-barred, and there was a delay of 400 days delay in appeal even before filing.
This is where the followed one Kerala High Court judgment.
Your Lordship. So Your Lordship, I want a specific order from here, because otherwise the department, what you know, Your Lordship, very much, because you are also aware of. So the order may be given that I may be allowed to file the VSBS and should be accepted.
You have heard, Mr. Aryak, that Amit Sharma and Mr. So-and-so. This is an appeal filed by the revenue challenging an order passed by the Income Tax Appellate Tribunal, B Bench, Kolkata, in ITA number 763/KOL/2022 for the assessment year 2013-14. The appeal was filed beyond time, and an application for condonation of delay was filed, which was heard, and that the assessee has been advised to avail the provisions of the direct tax Vivad Se Vishwas scheme within bracket VSVS dated 15th October 2024. However, one issue may crop up if the assessee files an application under VSVS by citing that the date fixed for eligible cases, as has been mentioned in paragraph 3 within bracket serial number 1 within bracket 2 i's. Identical issue arose for consideration before this court in the case of Principal Commission of Income Tax 1 Kolkata versus Ashish Kumar Ghosh, WPA 18282 of 2021, and by judgment dated 1st April 2022, this court had considered the very same issue and found that the assessee would be eligible to file a declaration under the provisions of the VSVS, and a direction was also issued to process such application. The judgment rendered in Ashish Kumar Ghosh will fully support the case of the assessee, and therefore the assessee is entitled to file an application under the VSVS scheme. Accordingly, the assessee is permitted to file the application and the department shall process the application in accordance with it.
Let kindly
List the
keep the appeal pending.
Yes, the appeal will be pending.
Yes, otherwise I can't file the VSVS.
List the appeal. Give a date in December.
Yes.
Monthly list of December. Very good.
Item number 13.
The appeal for the assessment.
13, 14,
My lord, a substantial question of law, my lord, it is in the paragraph number 8.
But assessee's own case was decided.
Lord, I had thought, Lord, Mr. Mojumdar will argue for me and will not get it admitted. Lord, it's
It's covered by us.
my lord, it's not, my lord, after Avisar, my lord.
Avisar, my lord, this is my lord.
Incriminating material, my lord, ought to have been found. No, my
No,
lord,
this
here-
is ATIA.
Yes, my lord. This is a, my lord, this is a case where, my lord, the tribunal has applied the ratio that since no incriminating material was found in case of this unabated assessment, therefore, my lord, these proceedings would go.
Avisar, my lord-
ATIA is not an issue.
ATIA, my lord, is there, but my lord,
But the
that's
main
only,
issue
my
is
lord.
this.
The main issue is, my lord, bogus addition, my lord. On the ground, my lord, that there were documents found, my lord, but the documents did not name, my lord, the assessee. My lord, the assessed person, my lord, must, his name, my lord, must be there.
Oh, ground number C is that.
Yes, my lord.
Ground C.
ATIA is there, my lord, ATIA is covered, my lord. That was the
But
main.
ATIA, I think you have not raised.
I have, my lord, in the.
But it is arising out of that assessment only.
Yes, my lord,
Oh, yes.
ATIA, my lord,
Ground
is
A.
the first ground.
And where is this finding regarding incriminating
Yes,
material?
my lord, if your lordship sees, my lord, the order, my lord, of the tribunal, my lord will kindly take, my lord, paragraph 4 at page 64. It begins from there.
Paragraph 18 of tribunal order and paragraph 10 of the CIT appeals order.
That is the conclusion. If your lordship, my lord, sees, my lord, the discussion is from paragraph 4 onwards. And paragraph 18 is, my lord, the ultimate conclusion, since we have held.
Paragraph number 13. 13. Internal is 14.
And my lord, paragraph 13 is material at page 70.
Yes.
এগুলো দাদা
প্রাইভেট লিমিটেড এটা অ্যাপিল এসেছিল হাইকোর্টে কোনটা ট্রাইব্যুনাল যে জুলাই করেছে এগুলো হাইকোর্টে এসেছিল নো আইডিয়া
My lord, a TIA ground, my lord, is paragraph 29, page 96. My lord, there is one more ground. My lord, on the labor charges, payments made to STPL, that is, my lord, page 95, paragraph 27.
Sir, please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 is directed against the order dated April 7, 2023 passed by the Income Tax Appellate Tribunal, Kolkata, A Bench, Kolkata in IT SSA number 42 / K1 41 and 41, 42, 43 and 44 / K1 / 2017 for the assessment years 2009, 10, 10, 11, 11, 12 and 12, 13. The revenue has raised the following substantial questions of law for consideration. Page 5 and 6, question numbers A, B and C, D not required. We have elaborately heard the learned advocates for the parties. The first question which has been suggested by the revenue is with regard to the deduction allowed under section 80 capital I capital A of the Act. We find that the learned tribunal has examined the factual position with regard to the eligibility of the assessee to claim deduction under section 80 I capital A capital I and found that the assessee is a private limited company engaged in the business of civil contracts. Search and seizure action under section 132 of the Act was conducted at Adhunik Group, ADHUNIK Group, on 17th and 18th December 2014. In compliance with the notice issued under section 153 capital A, the assessee filed the return declaring a total income of rupees 2, 55, 01, 100 after claiming deduction under section 80 capital I capital A. The assessing officer came to the conclusion that the assessee is a works contractor and not a developer and therefore not eligible for deduction under section 80 capital I capital A of the Act. The assessee challenged the order before the CIT, Commission of Income Tax (appeals) CITA, who allowed the assessee's appeal, which was challenged by the revenue before the tribunal. The tribunal, after considering the findings rendered by the CITA, on its part examined the factual position and found that the assessee is engaged in civil contract business and mainly carries out projects awarded by Public Works Department. And the claim under section 80 capital I capital A was made consistently and in the assessee's own case for the assessment year 2011 10-11, the issue was dealt with and the assessee was held to be eligible for claim of deduction under section 80 capital I capital A. Therefore, the revenue's appeal was dismissed. We find that the finding rendered by the tribunal cannot be faulted as the facts have been taken into consideration and no grounds have been made to interfere with the same. The second substantial question of law suggested was with regard to the payments made to STPL, all capitals, in lieu of labor contract. This issue was considered by the tribunal and after taking note of the facts found that for completing the government contracts, labor charges had to be paid and the assessing officer erroneously disallowed the labor charges paid to Messrs. Sakshi Trades Links Private Limited to almost 80.77% of the total labor cost. The tribunal, after taking note of the facts, approved the finding of the CIT on this aspect. We find no grounds to interfere with the said finding rendered by the tribunal. The third issue is regard to whether the tribunal committed an error by dismissing the appeal of the revenue on the issue of bogus share capital, despite the fact that additions were made on the basis of incriminating documents in the light of section 132 within bracket 4 capital A bracket close of the Act. We find this issue was elaborately considered by the tribunal. And the tribunal found that the addition made by the AO, assessing officer, towards bogus share capital is not based on any incriminating material. And other additions are also based on post-search inquiry or other material which were already disclosed by the assessee in its regular books of accounts, and therefore held the assessment to be bad in law. For coming to such conclusion, the learned tribunal also took note of various decisions passed by this court as well as the other high courts, and on facts it was found that in the instant case that there is no mention of the name of the assessee company in the seized material, and therefore the tribunal came to the conclusion that the presumption of the assessing officer that the share capital received by the assessee from the share subscriber companies referred in the said seized material can be treated as bogus share capital is bad in law or not justified. The finding rendered by the tribunal, learned tribunal, after considering the facts as well as taking note of the various legal proceedings, cannot be faulted. For the above reasons, the appeal fails and is dismissed, and the substantial questions of law are answered against the referee. This will be a common order in 13 and 14. Common order in 13 and 14.
Gratefully.
Yes.
Item number 15.
My lord, I appealing for the respondent, my lord.
Yes, sir. Not today.
No, my lord, I'm ready. I'm prepared, my lord. But I have prepared so many times.
Yes.
My lord, I'm just submitting with setting the background of this order, my lord. Initially, my lord, 147 order was passed. Thereafter, PCIT found that there was no examination on the part of the assessing officer. And he found that more than 200 companies, they were on their own, came to the assessing officer and got the assessment reopened. And with minor addition, so PCIT invoked 263 and directed the assessing officer to examine and call the directors of the investor company to prove their identity. During the proceeding, my lord, in giving effect proceedings, the assessee did not appear in spite of several notices. In fact, assessing officer sent inspector to the place of the assessee, but assessee was not found. And the investor companies, they sent their replies. There were around 26 investors. Out of those, 22 sent replies, but none of the directors of none of the companies came forward. And since there was a direction by the PCIT to examine the directors, identity was not proved. So assessing officer made addition. And in the meantime, one more thing, that 2623 order was challenged by the assessee, but appeal was thereafter assessee, this giving after challenge the order as a CIT appeal, affirm the order, additions. Against that order, my lord, the assessee filed appeal before the tribunal. Now the tribunal come to a different conclusion. Tribunal come to a conclusion that all the materials were before the assessing officer, and the assessee has been able to establish the genuineness of the transactions on that. Tribunal has not stated anything about the examination of the directors. My lord knows, my lord is aware that has passed several orders in this kind of case. My lord, there are three aspects. One is the identity of the investor companies,
Genuineness.
credit worthiness of the, whether that investor has the capacity to invest or not. And third, genuineness of the transaction. In this case, none of these points have been established. My lord, on the one of the last occasion, my lord, the assessee had filed a compilation.
But the learned tribunal says that all the share subscribers responded to the notices issued under
Yes,
section
this is the
133(6).
compilation, my lord. My lord, I have
then the AO should point out some discrepancy in their statement.
Nobody, my lord, I was candid. Neither the assessing officer has pointed out, nor the tribunal. Tribunal could have looked into these materials.
No. It is the duty of the AO.
My lord, the assessing
That is
officer.
why, if you please come to page 44, para 8, middle of about 5 lines or 6 lines from the top, para 8, we also take note of the fact that all share subscriber companies have responded notices issued under 133(6). AO has not bothered to discount or point out any defect or deficiency in the documents furnished by the share subscribing companies. Evidences furnished by them neither controverted by the AO during the assessment proceedings, nor anything substantive brought on record to justify addition. As the AO simply added the amount of share capital share premium on the ground assessee has not produced the director share loan. AO ignored the reply given by the assessee in response to the notice under 133(6), which are on record under due acknowledged seal, stamp of his good office. Perusal so-and-so note CIT has perused the evidence and on their exam sustained the addition. Thus, going by the records placed by the assessee and by all the share subscribers in response to the notice, it can be safely held the assessee discharges initial burden. So the burden is on the department to show that the documents were not acceptable or there was some defect, discrepancy.
My lord, that's why, my lord, initially I submitted, my lord, neither the assessee participated in the proceedings, nor the directors of the.
Then tribunal has also noted Sri Ladas.
My lord,
Sri Ladas, I think appeal filed before Supreme Court was dismissed. I don't know. NRI Iron and Steel.
NRI, my lord.
Was distinguished. On facts, it is clear, sir. Suppose the directors didn't appear, the share subscribers companies also did not respond to 133(6), then probably the AO might be justified in drawing an adverse inference. But they have responded. All of them have responded, made their submissions, placed documents. So he should examine those documents and point out this is the discrepancy, this is wrong, that is not wrong.
My lord, this compilation has been filed by the SSC before this honorable court, my lord. I have prepared a summary of this compilation. My lord, kindly have a look. My lord, these are the investor companies, the amount invested in the assessee company, and third is the source. All these companies have received share application money from another company and the same amount. It's a round tripping. My lord, in fact, in this
Profit during the year.
Yes.
433.
Yes, my lord.
293.
93. And some of the assessee, some of the investor has not provided data.
But this exercise should have been done by, not by Mr. Amit Sharma, but should have been done by the assessing. Please come. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 19.
My lord, may I suggest one thing, my lord? Remanded back. My lord.
Director within the.
My lord, one thing, my lord, one aspect, my lord, my lord, this assessee was incorporated and within 7 months, more than 15 crores were put in. At the premium of
you catch them for the next assessment.
My lord, yeah, at the premium of 10 rupees. My lord, this is the prudence, my lord. Somebody will put in money in the anticipation of profit when premium will be charged. When the company has a sound business and the future prospect. The company which is a nascent stage. And this explanation for payment of premium, my lord, has not been explained by anybody. So, my lord, kindly.
Income Tax Act 1961 is dated October 26, 2023. Passed by the Income Tax Appellate Tribunal, C Bench, Calcutta, within bracket Tribunal, ITA number 1842/K1/2017 for the assessment year 2009-10. The revenue has raised the following substantial questions of law for consideration. Page number 8, ground. Page 9. We have heard so and so. The issue which falls for consideration is whether the learned tribunal was justified in setting aside the addition made under section 68 of the Act. The learned tribunal has examined the factual position and has rendered the following finding. Please quote paragraph 8 of the tribunal order in page 44 and up to para 8.2 in page. The above factual position is not controverted by the department. However, Mr. Amit Sharma, the learned senior standing counsel for the appellant department, would strenuously contend that on examination of the documents which are produced by the share subscribing companies, it is evidently clear that none of those companies had any creditworthiness to invest in the shares of the assessee company, that too at a high premium. Unfortunately, examination of the factual position as sought for cannot be done in an appeal filed under section 260 capital A of the Income Tax Act, and it is the duty of the assessing officer to have done such an exercise. The learned tribunal on facts found that all the share subscriber companies have responded to the notices issued under section 133 within bracket 6 of the Act and had produced and made their submissions and produced documents. Therefore, it was the duty on the assessing officer to deal with those documents, point out any discrepancies or defects, and then make the addition. However, the assessing officer failed to do so, and the CITA also committed the same error. Therefore, we find that the tribunal was well justified in allowing the assessee's appeal, and in doing so, the learned tribunal has also taken note of the various decisions of this court and recorded recorded reasons for allowing the appeal. Thus, we find no grounds to interfere with the order passed to the learned tribunal. Appeal dismissed.
Multiple oblige.
Yes. Next.
Item number 16.
I had hard luck, my lord, for me. My lord, in this matter, my lord, I'm led by Mr. Mitro, but this is not coming to court, my lord.
We'll say not today.
My lord.
Not today.
Item number 17.
I need not take it tomorrow, next time.
All right. Not today.
Item number 18.
This is my application, my lord. May I be permitted to file the affidavit of service? The item has been undelivered without instruction. That is the, it has come back with an endorsement, my lord.
Left without instruction.
Without instructions.
And who appeared for the assessee before the tribunal? None appeared.
That is in the miscellaneous application, my lord.
Oh, in the main matter.
None appeared is also before the tribunal. There was an order under section 143(3), my lord. Then subsequently, the principal CIT has taken up the issue and invoked 263. Now, the reason for invoking the 263 is at page 13. That is, it was found on examining the assessment records, the contribution towards the Provident Fund was deposited after the due date as appeared in the tax audit report, and it was submitted subsequently. Now, in the meantime, what happened, Your Lordship? Now they traveled up to the tribunal, and the tribunal decided in favor of the SSC and said, no, it was.
The tribunal remanded the matter.
Yes, remanded the matter to the assessing officer.
Yes. Then what
happened? This was the order passed. This was the order passed on 5th of September. Then subsequently, Your Lordship, the checkmates order passed by the Honorable Apex Court that I have annexed at page 23. That the order was passed on 12th of August 22, my lord. 5th of September, tribunal the tribunal's order was passed. Subsequently, on 12th of October 22. Now then, if your lordship comes to page 44, the department filed a miscellaneous application before the tribunal. Now, without going into the merits of the case, only on the point of the limitation, it was dismissed that there was a delay of 81. So we wanted to agitate. Yes, my lord. If this can be taken up by the tribunal, my lord, and be decided in the light of the checkmate's decision, my lord. Because it is now, it's a well settled proposition that
is there power to condone the delay?
The power to the condone, they are saying that they don't have, but they can exercise. Yes.
254. They should have power.
They can always exercise their discretionary power to do so, my lord.
No, there is no power, Smita.
That is why they have held that as per under section 254, we do not have the power to condone the delay. So if your lordship can pass an order and directing the tribunal.
If it is a petition, something can be done. This is a 260A appeal.
But the settled proposition of the law is otherwise different, and that goes against the SSC. So now the SSC is getting the benefit of that. But the checkmates, it is a settled proposition, my lord, as my lord knows it. That if it is not filed, then it will be added in the hands of the SSC.
Tribunal may at any time within 6 months from the end of the month in which the order was passed, with a view to rectifying any mistake apparent from the record, amend any order passed by it under subsection 1, and shall make such amendment if the mistake is brought to its notice by the assessee or the assessing officer.
Here it is, the delay is more than that, my lord. Because the tribunal has held in favor of the assessee in the view of the Colindi and Phillips. But then subsequently the checkmate has come into play. So
No, the matter is now remanded.
before the
AO.
assessing officer,
So
my
the
lord.
AO can apply checkmate.
But only one line observation with regard to so that they can go back to the, because it's only wanted to agitate the issue before the tribunal so that it can be
No, please
decided.
come to page 21.
21, my lord. Yes. It has been remanded back. I know, my
To
lord.
our mind.
Paragraph 8.
So though they have referred to Coal India,
Yes, my lord.
uh,
But that proposition has been upset by the checkmate, my lord. And it's pat on the point, my lord, that it should be assessed in the hands of the assessee.
I think
It's
one
quell-
page of the tribunal order is missing.
Yes, my lord. I bow down, my lord. It's the mistake.
This appeal has been filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act, challenging the order dated 29/11/2023 passed by the Income Tax Appellate Tribunal A Bench Kolkata in MA number 35/KOL/2023 in ITA number 232/KOL/2022 for the assessment year 2017-18. The revenue has raised the following substantial questions of law for consideration. 6 and page 6, sir. A and B. C, D not required. We have heard Smita Das there, learned as senior standing counsel for the appellant revenue. The notice sent to the respondent assessee has returned with the endorsement left without intimation, inverted comma. Considering the narrow scope of this appeal, the same is taken up for decision. The learned tribunal has dismissed the miscellaneous application filed by the filed by the revenue in MA number 35/KOL/2023 under section 254 of the Act on the ground that it is barred by time. The finding rendered by the learned tribunal cannot be faulted since the miscellaneous application filed by the revenue was well beyond the time limit prescribed under subsection 2 of section 254 of the Act. Therefore, there are no grounds made out for interfering with the order passed by the learned tribunal. Furthermore, we note that in the order dated 5th September 2022, the learned tribunal, while allowing the appeal, set aside the order passed by the order passed under section 263 of the Act. However, after setting aside the said order, the tribunal has observed, while setting aside such order, the tribunal has observed that once a fact was brought to the notice of the Commissioner of Income Tax, he should have got it verified from the assessing officer before recording a finding that the assessment is erroneous as much as prejudicial to the interest of revenue. The tribunal found that the order of the CIT is totally silent on this aspect, and therefore the appeal filed by the assessee was allowed for statistical purposes, and the matter was remanded, and this issue was remanded to the CIT with the direction that a remand report be called for from the assessing officer, and if it is proved that all these payments have been made before the due date of filing of the return, then proceedings under section 263 will be dropped. However, it is to be noted that the don't say however, it is to be noted that the learned tribunal had allowed the appeal filed by the SSC and remanded the matter back to the CIT by taking note of the decision of this court in the case of Messrs. Philip Carbon Black Limited and Messrs. Coal India Limited. However, the said decision no longer is good law in the light of the decision of the Honorable Supreme Court in Checkmate Services Private Limited versus Commission of Income Tax 2022 143 taxman.com 178 within bracket AC, wherein it was held that for the assessment years prior to 2021-2022, non-obstante clause under section 43 capital B could not apply in case of amounts which were held in trust, as was case of employees' contribution, which were deducted from their income and was held in trust by the assessee employer as per section 2 within bracket 24, normal 24, numerical 24, within bracket X 10, Roman 10, thus, said clause would not absolve assessee hyphen employer from its liability to deposit employees' contribution apostrophe S on or before due date as a condition for deduction. Thus, it goes without saying that in the remand proceedings, the CIT has to take note of the decision of the Honorable Supreme Court in Checkmate Services Private Limited, as also the assessing officer while submitting a remand report. Full stop. With these observations, the appeal stands disposed. Consequently, the substantial questions of law are left open. Next.
Item number 19.
For the respondent.
But in the SSC's own case for the earlier year, 3 of the questions have been admitted. There's an additional 4th question, if my lords are pleased to have page 24.
Page 4.
4th question is also with regard to the expenditure for earning the dividend income.
AD2 is covered. No.
Here, the tribunal has not, the assessee's contention was that the officer has not expressed any dissatisfaction with the assessee's.
That is required.
So, yes, so there
are several decisions.
Yes, but in assessee's own case, in fact, because the tribunal has taken this view earlier, they're simply following that same view. And my lords have been pleased to admit the appeals. If my lords are pleased to have volume 3, page 334.
Second is also 14A.
Yes, for 1, 2, and 3, that 3 is challenging the findings as perverse.
Then 4 is 115 JB.
Yes, but this point was all along being decided in assessee's favor. But tribunal this year, without really giving any substantial reason, it has disagreed with its own order and decided it against this. Although there's a decision of our court on this point.
Where is the tribunal's finding on 115 JB?
Yes, but kindly have page 285.
Volume 2.
Volume 2. Starts from page 281.
But how do they get, how does the tribunal get over the argument in para 29, 282?
They do not. They simply say that whatever.
And against 13, 14, 14, 15, no appeal to the High Court?
No, not by the revenue on this point. Not on this.
115. Then that is gone.
No,
We'll allow the appeal so far as ground number 4. Admit the appeal for 1 to 3. No, all 4 can be admitted.
All 4 can.
All.
But in fact, the different years are accumulating now.
Mm.
Perhaps this will not take much time to.
All right. Appeal is admitted on the following substantial questions of law. Page 24 and 25, sir. 1, 2, 3, 4. List this appeal along with ITAT 137 of 2023. The paper book dispensed to.
Yes, ma'am. It can be heard on these papers.
JP Kaitan.
No, the other matters are appearing in the monthly list note, items 77 to 82. I'm grateful.
Item number 20.
No, this matter, my lord.
Low tax effect.
No,
No,
not that. My lord,
Bogus expenditure.
my lord, the assessee never appeared. He did not appear before that assessing officer.
He was so confident.
Did not appear before the CIT. He did not appear before the tribunal. But, my lord, he filed the appeal. Before the CIT, he filed the appeal. Now, if your lordship is kindly takes, my lord, page 12, is the disallowance, my lord, given by the assessing officer, and at page 11, the assessing officer said that in spite of repeated services, none appeared.
Keep it 10%.
In fact, the tribunal has increased the percentage, the rate to
From
10.
5 to 10. No. What I am on is, my lord, kindly see.
You want 100%.
My lord, kindly see the at page 15 is the, my lord, 250 order. There, they have given the grounds on which the appeal was preferred by the assessee. But thereafter, the paragraph says that 5 notices were given to the assessee. He did not appear, even before the before the commissioner. Thereafter, he reduced the amount to 5% of the turnover. Which, according to me, could not have been done because there was nobody to argue this case before by the assessee. So it was nobody's case that it could be reduced to 5%. And the tribunal, this tribunal is also expertise. There also the assessee did not appear. And they reduced it to, increase it to 10%. But this 5%, 10%, this argument was never advanced by anybody.
But what the CIT appeal says is,
yes,
the assessing officer concentrated only on the purchases made, but not the sale.
But then kindly see, the assessing officer has recorded that all these.
No, what happened to the notice you have served?
Yes. Delay was following the tradition, they would not appear before your lordship. All these Sonthalia group of companies, they are based in the same premises And my lord, they are carrying on business amongst themselves.
According to the AO, it's all book entry.
It is all book entry. My lord, kindly take page 12. There is no actual business activities or transactions.
Yesterday, we heard one matter, PIL. There also, it is entire Santolia. Bangladeshi. They say they are all Bangladesh national. Illegally, they are coming. All right, we have heard Mr. So-and-so, so-and-so. Appeal admitted on the following substantial questions of law. A to E. A to E.
Item number 21.
This is my application. My lord, the question of law at page 5, paragraph 7, my lord. The moot question before your lordship, if your lordship kindly takes up the question of law that with regard to my lord has already held in the BST Infratech Limited, and that Swati Bajaj was also taken care of, my lord. This is also a case of the unexplained share transaction, my lord. Now, the assessing officer has made an addition of 3 crores, my lord, and treated as unexplained cash credit, as it was found in the books of the account, and there was no proper explanation to that. Now, if your lordship kindly comes to page 38, that's the order of the CITA, my lord. May I place the relevant portion, my lord? The summing up during the relevant year, the appellant received the share application money amounting to rupees 3 crores from 4 group companies, namely the Citizen Securities Limited, Decon Projects, Conglomerate, Quick Pay, who are regularly filing income tax return and complying with the Companies Act. Further, the investment into the assessee company by investing company has made from its own sources. The source of money advanced to the appellant company was the redemption of the mutual fund, refund of loan and borrowed fund taken from the bank, utilize overdraft
The
facility.
entire thing is factual.
But the tribunal did not give any independent finding. It's only relying of the CIT's order has arrived at a finding that...
No, it has examined the facts. You come to para 6, page 55.
But
there are 4 companies. Then what was the amount invested? Then it found that they
page
have a positive
56, my
return has
lord.
been filed.
Yes, page 56, the assessee has filed all these documents. The only area of difference is between the assessee and the learned assessee
That
as
is
to
up to
why
you
the
to decide.
subscriber will
He wants to
invest.
make some charity, some donation, some gift. Loss-making company, I will invest. If he wants to go and jump into the sea, how you can prevent it? This
He
appeal
doesn't have the capacity, but still, your lordship.
This
That's the
appeal
only
by the
thing they
revenue
could have
under section
drawn an
260
inference.
Cap of Income Tax Act 1961. Within bracket, the act is directed against the order dated November 8, 2023, passed by the Income Tax Appellate Tribunal A Bench, Kolkata, within bracket Tribunal, in ITA number 666/KOL/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page 5 and 6, question A and B. We have heard so-and-so. Smita Das, Priti Doria, Sabrodush Madhundar, Swapna Das, Siddharth Das. The revenue was on appeal before the learned tribunal, challenging the order passed by the Commissioner of Income Tax within appeals, within bracket appeals, NFAC, Delhi, dated 25th March 2023. by which the assessee's appeal was allowed and the addition made under section 68 was set aside. The learned tribunal has extensively quoted the factual findings recorded by the CITA upon appreciation of the documents which are placed by the assessee, as well as the subscribing, as well as the group companies. The tribunal, after referring to the finding recorded by the CITA, has on its part re-examined the factual position and found that no case has been made out for addition under section 68 of the Act. Thus, we find there is no substantial question of law arising for consideration in this appeal dismissal. Next.
Item number 22.
Yes.
My lord, I am appearing for the petitioner. My lord, your petitioner wishes to opt the ongoing scheme of the government Viwas se Vishwas. So kindly adjourn the matter for 4 weeks. At least 4 weeks in the meantime.
We have heard so and so. The learned advocate for the appellant submitted that the appellant assessee is desirous of availing the benefit under the VS scheme.
Direct tax Viwas se Vishwas scheme.
And request for adjournment. Adjourn.
4 weeks, my lord. I am grateful.
Item number 23.
My lord, in this matter, I had sought instructions from the department regarding tax effect, my lord, because I am myself in doubt. I think it is below tax effect. Kindly have a look, my lord, at this notification.
In the grounds, there will be one paragraph.
The tax effect is here mentioned at 8,96,000, but this is penalty matter, my lord. So, my lord, kindly come to the para 5.1. Third page, my lord. 5.1, last line, my lord. In case of penalty orders, the tax
quantum of penalty deleted or reduced.
My lord, here the penalty was imposed. That was challenged before the CIT appeal. Order was affirmed. The tribunals reversed the order and directed the assessing officer to delete the penalty.
So how much was deleted? 8,96,000.
That is the entire order.
Then it is below the tax effect.
Since I was not getting any instructions for the department.
We will not record anything. We will pass an order. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 is directed against the order dated 21st August 2023 passed by the Income Tax Appellate Tribunal B Bench Calcutta in ITA number 126/KOL/2023 for the assessment year 2012-13. Though 3 substantial questions of law have been suggested by the revenue, in paragraph 16 of the memo of appeal, the tax effect involved in this appeal has been mentioned as rupees 8,96,232. Though the revenue takes a stand that the case falls under the exception clause in the said circular, it has not been clearly pointed out under which clause, which exception clause the revenue seeks to bring the matter. In the absence of any such specific averment, we are required to go by the quantum of tax involved in this appeal, which admittedly is lesser than the threshold limit. Hence, the revenue cannot prosecute this appeal any further, and the appeal stands disposed of on the ground of low tax effect, and the substantial question of law is left out. You can give it back.
Item number 24.
I am for the respondent.
My lord,
pertains to amalgamation of the company, but the situation is that the assessee, before the assessing officer, never pointed out that the company has been amalgamated. Your Lordship, kindly see the stay petition paragraph number. Firstly, let's see the stay petition, paragraph number B, C, D, E. The CIT appeal also held in favor of the review, taking the point that assessee never pointed out the amalgamation to the assessing officer. Now the tribunal will revert the same, saying that the company was in existence, and the the Honorable Supreme Court, Your Lordship, knows that in Mahagun matters, they taken the view that if the assessing officer not pointed out that the assessee has been amalgamated, then the proceedings can be validated. Now, Your Lordship, kindly see the most importantly page 38 of the CIT appeals order. It is a case of cash trial of 9 crores and odd. Page 38 of the CIT appeals order.
Now, how does the tribunal distinguish this Mahagwan?
Mahagun not placed before the tribunal.
No, it is placed. Page 75.
It is placed,
It is placed, but not properly addressed.
My lords, if I am allowed to state that one thing which on the basis of which the Honorable Tribunal has distinguished is that in the reasons to believe itself, the fact of amalgamation was recorded. What has happened, my lord, that the assessing officer has referred to certain statement of few alleged accommodation entry operators. There has been some question put to those entry operators. The fact of amalgamation has been put to them, and the specific questions were asked.
That was within the knowledge of
That was within the knowledge of the assessing officer.
Your Lordship, kindly see page 38 for my satisfaction. CIT appeals order.
Sir, page 77, para 9. The AO, he already had the knowledge about amalgamation, which had taken place within the GPT group, since questions were raised while recording statement of persons, which formed the basis for initiation of proceeding 148, relevant extracts of the order of jurisdiction or so and so, which approved. It is noted that notices were issued to the central government because they will be heard.
Yes, Milord, but the...
My lords, I have the copies of reasons to believe. Seek leave of the court. Sir, this part of the paper book which was furnished before the tribunal. Page 71 onwards is the reasons to believe. Kindly come to page 75, my lords. In the middle, Your Honor, page 75 on the top, in the middle, Your Honor, further
79.
75. Further, in order to confirm the transaction of accommodation entries, statement of Shri Ramesh Chand Daga, Director of InStyle Trading, was also recorded under 131 by the Department of the Income Tax Department during the course of search and seizure operation at GPT Group. The relevant portion of the statement is reproduced. Kindly come to question number 8, ma'am. As stated above, you were the director in following concern which stands amalgamated. Company name InStyle Trading. Your Honor, the allegation of the amount has been received from InStyle Trading Private Limited with the SSC company, GPT Ventures Private Limited, which was again amalgamated with the second company. Another question number 9 is also the facts about amalgamation is recorded here. You have been director of InStyle Trading from its inception year until in amalgamation.
It should be duty of the assessee to inform the assessing officer. Now, the question.
No, but the assessing officer knows about it. That is why he has questioned them.
Now, hearing 9 crores and odd cash trial, company amalgamated from A, B to C, and now for the reason of amalgamation, the entity,
my lord,
the tax has been evaded. Only page 38. Similar CIT appeals order. Well, CIT appeals also dealt with. But in
No, in this Mahan relators,
and
there was a suppression of facts.
yes, you Lordship, kindly see, my Lord, the page 38, SSC filed revised return on 3rd 12/2018 also in the name of GPT. Thereafter, my Lord, SSC had used the letter of GPT Ventures Private Limited on 3/12/2018 also. Thereafter, my Lord, once it was intimated to the AO that merger has been taken place, then AO has issued notice under section 148 in the name of GPT Ventures since amalgamated to the Messrs GPT Sons Private Limited. But why, my Lord, the SSC has filed return on 3rd December 2018 in the name of GPT Ventures Private Limited only. Now he is saying that amalgamation has been done in the year of 2012. And thereafter, I mean,
What is your reply?
My lords, what I am trying to state. They state that they got information about the amalgamation only on the 29th of December 2024 when the order was passed. My lord, I have enclosed their focus notice, which is at page 79.
Let my give the.
I am giving the answer to that also.
I can also go through.
I have given you a copy.
Yes.
What this is under 147.
This is under 147. The show cause notice was issued. The date of the show cause notice is 6th of December 2018.
Yes.
It is the fact of amalgamation is recorded here. And they state in their petition that they came to know about the amalgamation only on 29th of December.
That is wrong.
That is wrong.
But then
I have filed my return. My lord, when the notice has been issued, I didn't comply, didn't file my return. But there was constant pressure. And on the income tax portal, there was no other mechanism to file my return. They didn't accept my physical return. There is no record of that. But I was forced to file my return because otherwise on the income tax portal, there is no other mechanism to file my return.
So you had to file the return in the name of a non-existing
company. Otherwise, I could
not
file.
Department of Affairs.
Why the existing entity not file the return? Because the existing entity also had PAN number.
GPT Sons Private Limited was merged and amalgamated with GPT Ventures, which was within the knowledge of the department as early as 2018. So the theory which you made
Still, the SSC filed return in the name of GPT.
Because they had no other option.
No, at that point of time, the concern was non-existing. Existing concern was there. They should file return in the name of the existing concern.
Your Honor, the notice was issued, my lords, in the PAN of that non-existent company. It was not appearing on the portal of the subsequent company, the amalgamated company. I had no option whatsoever to file my return online. In the case of a company, the return can only be filed on the income tax portal.
So whether this argument was raised before the tribunal?
Argument?
Nothing is here. Now the submission has been
whatever
made
submissions you are making now was not the submission of the revenue before the tribunal.
No, that proper submission has not been made. But this is the case 9 crores and odd tax has been evaded.
My lord, I have to say that argument was
from the
raised at para 8.1 of the tribunal's order. They have referred to a judgment of Calcutta, Honorable Calcutta High Court, Judicial High Court at para 8.1. Page number 71 of the tribunal's order. Para 8.1, page 71.
So it cannot cure the defect. This appeal by the revenue under section 260 cap A of the Income Tax Act 1961, within bracket the act is directed against the order dated 9th May 2023, passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket tribunal in ITA 491/KOL/2021 for the assessment year 2011-12. The revenue has raised the following substantial questions of law for consideration. Page number 5 and 6, A, B, C, D. E also. We have heard so also. The short question which falls for consideration in this appeal is whether the reopening of the assessment was valid in law, in as much as the notice was admittedly sent to a non-existing entity. Before us, the learned senior standing counsel will vehemently contend that the fact that the assessee company was amalgamated with GPT Ventures Private Limited was never disclosed to the assessing officer, and they came to know of it only in the year 2024. This submission appears to have not been raised in such a form before the learned tribunal. Nonetheless, we considered the said submission and we found the submission to be factually incorrect. As the assessing officer was aware of the same, aware of the amalgamation, even at the time when notice was issued under section 140, when proceedings were initiated under section 147 of the Act, pursuant to notice dated 6/12/2018. Apart from that, in the reasons to believe, which was appended to the notice, assessing officer has specifically referred to the details regarding the amalgamation. This aspect of the matter, therefore, the submission of the revenue it cannot be accepted as it is factually incorrect. The second aspect is with contending that the assessee had filed the return in the name of the unamalgamated, in the name of the company prior to its amalgamation. This issue was also considered by the learned tribunal, and after taking note of the decision of this court in the case of IK Agencies Private Limited versus Commission of Wealth Tax 2012 20taxman.com 731 within bracket Calcutta, the contention was rejected since the fact that the real assessee subsequently filed its return with objection that such notice is invalid cannot cure the defect which goes to the root of the jurisdiction to reopen the proceedings. Further, it was held that the said provision cannot cure a defect of nature involved in the case where no notice at all has been issued upon the real assessee responsible for payment of the dues. The learned tribunal also took note of the decision in the case of Alamelu Veerappan versus ITO 2018 95taxman.com 155 within bracket Madras. It is in page 72, which was rendered by relying upon the decision of the Honorable Supreme Court in CIT versus Amarchand N. Shroff 1963 48 ITR 59 within bracket SC.
But only, my lord. Well, may I only place, my lord, only one paragraph of Mohagun, page paragraph 41.
The learned advocate, which paragraph?
Last paragraph 41, my lord. Well, here also CIT appeals files, my lord, in the name of, my lord, not the existing entity.
The learned counsel, learned senior standing counsel appearing for the revenue place reliance on the decision of the Honorable Supreme Court in PCIT versus Maham MAHAGUN Relators Private Limited 2022 443 ITR 194 within bracket SC. In fact, this decision was also placed before the learned tribunal by the revenue. The learned tribunal took note of the facts of the said case and found that in the said case, the assessee had suppressed the fact of amalgamation. However, in the instant case, as pointed out earlier, the fact of amalgamation was well within the knowledge of the assessing officer as early as in the year 2018. So far as filing of return in the name of the assessee company prior to its amalgamation was a event which could not be avoided by the assessee, avoided by the assessee. And in any event, mere filing of such a return would not be cannot be taken to be a ground to cure the inherent defect which goes to the root of the matter. Therefore, the decision of the Honorable Supreme Court in Organ Relators Private Limited cannot be of any assistance to the facts and circumstances of the present case. For the above reasons, the appeal is dismissed and the substantial questions of law are answered against it. We'll stop with this, sir.
May I be permitted to mention like Steve Margin? The filings, filing section is not accepting the filing, my lord. When the tax effect is less than the prescribed schedule, my lord. In spite of that, we have said, my lord, this is a penny stock matter. We have mentioned, but
no, they have to.
And also, my lord, they are saying that appeal valuation has to. Yes, but they are asking for, because the registrar
is not for the filing section to decide.
Yes, my lord. Yes, and they are also asking for appeal valuation has to be mentioned in the memorandum of appeal, my lord.
No, you mentioned that.
Yes.
You may mention, you give it in
but
one
they are
time.
not accepting that on the ground. They are rejecting. They are
You tell them it has to be accepted. It is not for them to.
Yes. Although, my lord, we are
May I have
specifically.
Lordship's kind leave to mention an extremely urgent matter, my lord, for assignment purposes, my lord. Yesterday, my lord, the Birla Lodha offshoot matter, interim order got vacated yesterday. We have filed an appeal yesterday itself. Today it was released, my lord, by the Honorable Justice Showman says they have presided division.
The order is not yet uploaded, but it has been released.
If it can
the
be,
order has not
can
yet
be
been
assigned
uploaded,
today
but
itself,
it has
my
been
lord.
released.
There is an
But
urgency,
only
my lord.
one thing, which I want to indicate,
The moment it is signed, I will do it.
Grateful. I'm very
To yesterday 8 p.m. there is nothing pending with me.
Grateful.
Okay.
Grateful.
Before you mention, please verify. Okay. If
Very
there is any inordinate delay, you ask me. I will.
There was an urgency, my lord. I'd like to move
I have
today.
cleared. In fact, old matters were all there. I came back, went back to my home state, came back, stayed here for 6 days during vacation. I have cleared it.
We actually wanted to
The
move it today
moment
itself, my lord. That's why I mentioned.
yesterday also somebody mentioned. Who mentioned? Pratyush Shuna and Mr. Who Banerjee appeared, no? Psychiatrist Siddhartha Banerjee appeared.
Well, we have to move it today if possible. That's the whole program.
He has to sign, sir. I can't pull the file.
The papers have come possibly.
We don't know. If it comes, definitely it will be done.
Grateful, my lord.